thank you for joining us for our April Fool's Day version of our Spring Business webinar. And you're lucky to be here to hear from our experts here, so you won't have any April Fool's surprises today with your human resources departments. Without further ado, once again, thank you all for being here. Christine and Elijah, we appreciate your time today. And if you don't mind, once I get you to share your screen in a second, just tell us a little bit about yourselves and about what we're going to be talking about today.
Wonderful. So let me share my screen here first. So yeah, my name is Christine Green. I'm an attorney with Stanton Law, LLC. We're a small boutique firm representing small to medium-sized businesses, and we're located in the Midtown area. I've been practicing employment law, counseling and litigation, and business counseling for 12 plus years. And I'm excited to be here to talk to you guys today about this murky area of the ADA, FMLA, and workers' comp and how they interplay and intersect and oftentimes confuse us and trip us up. So Elijah, I'll let you introduce yourself too.
Hi, my name is Elijah Davis. My background is primarily in federal tax and the completely unrelated realm of insurance defense and workers' compensation. So representing the employer and the insurance company and workers' compensation claims.
All right, so basically our overview is we're going to look at the FMLA, the ADA, and workers' comp. And we're going to look at, what qualifies for that, how much leave do employees get, and what are the rights upon return. That's in general. And then we'll also do some fancy Venn diagrams where we go through examples of what would qualify for FMLA, ADA, workers' comp, and where they overlap. That'll be fun. So essentially the FMLA, the Family Medical Leave Act, and the ADA, the Americans with Disabilities Act, they are federal statutes. The workers' comp is a creature of state statute. So with the FMLA, that applies to serious health conditions. And what that means is basically an injury, an illness, an impairment, or a physical or mental condition that involves inpatient care and or continuing treatment by a healthcare provider. So inpatient incapacity would be like 3 days of supervised care, pregnancy or prenatal incapacity. You could have a chronic serious health condition that requires ongoing treatment. And essentially any treatment to avoid incapacity as well. And then there's a whole separate military leave section to be aware of. And there's qualifying exigency, that's 12 weeks. And then there's caring for a family member who has a serious health condition or injury related to military leave as well. And that's 26 weeks. So that's essentially what the FMLA is. We'll bring that to life in a few minutes because I'm sure that's clear as mud. Then there's the ADA, it covers qualified individuals with a disability. And disability is defined as a physical or mental impairment that substantially limits one or more major life activity. That definition is incredibly broad. You're likely going to be disabled. And we rarely ever recommend fighting an employee, the claim that an employee is disabled, unless there are some very obvious circumstances where they're lying about that, or it's clear that it's not a disability under the law. But so what the ADA requires is a reasonable accommodation for an individual with a disability, unless that reasonable accommodation creates an undue hardship. And to flesh that out a little bit more, the reasonable accommodation is designed to help an employee perform the essential functions of their job. So examples, if there's someone with chronic sciatica and they need an ergonomically correct chair or a stand-up desk or something along those lines, it will help them perform the essential functions of the job. And that would be a form of a reasonable accommodation in general. And we'll go more into detail about that on the next slide, but I'll turn it over to Elijah to talk about workers' comp.
So workers' comp is going to apply to an accidental injury arising out of and in the course of employment. And what that essentially means is, it can't be something completely unrelated to the employment. You can't have someone walking down the street on their off day and claim that that's a work injury. There's also, and this is beyond today's presentation, but there's also a ton of different carve-outs related to whether something is in the course of employment. So, I'll expand upon that in just a second on the next slide.
Okay. So eligibility for FMLA, the employee must have worked for the employer at least 12 months, and within those 12 months, at least 1,250 hours using FLSA principles. And also keep in mind that the FMLA does not apply to employers with fewer than 50 employees. So you have to have 50 employees for the FMLA to apply to that employer. And then the next question is the employee eligible? And that's where you look at how long they've worked for the company and for how many hours. But also, if the employer doesn't have 50 employees within 75 miles. So if you have 25 employees in Atlanta and 25 employees in Texas, you don't have 50 within 75 miles. But oddly, it doesn't mean that it doesn't apply to that employer, so you still have to post the notice. It just means that none of the employees are eligible, to make that extra confusing. So most employers need to post the notice, the FMLA poster, in the break room, or if you're virtual, send it out with your handbook information. So that's the FMLA eligibility. ADA eligibility is the ADA applies to employers with 15 or more employees, and it starts as soon as you hire that person. And like I said before, it applies to qualified individuals with disability defined by law. And what that word qualified means is if an individual has a disability, but there is no accommodation, reasonable accommodation that you could provide to that employee to help him or her, they perform the essential functions of the job, then they're not actually qualified. And that, we can get further into that as this PowerPoint goes, but generally speaking, you just really want to look at whether they have a disability at first, and then try to accommodate them. And then if you can't, then they're actually not qualified, if that makes sense. Okay, Elijah, to you on the workers' comp.
Yeah, so for workers' comp, this is another protection that the employee has immediately upon employment. So they clock in at the time clock on their first day, they turn around to go to work and they slip on something and they get injured, they're going to be covered under workers' comp if it applies to the employer. Now, in Georgia, the Workers' Comp Act applies to every employer that has 3 or more employees. So if that applies to you, you are subject to the Workers' Comp Act, and you should absolutely have workers' compensation coverage. The benefit, again, this could be an entirely separate presentation, but in workers' comp, the benefit of subjecting yourself to the act is that it becomes the exclusive remedy to the employee for any injuries that they sustain at work. So they can't file a tort claim against you and collect under that, which could allow for additional damages, punitive damages that are not present in workers' comp. So one way that a company can subject themselves to the act if they don't have 3 employees is to just purchase workers' compensation insurance coverage that is going to cover them. And then they can voluntarily subject themselves to the act. So just remember, 3 or more, you have to have it. Less than 3, you should probably consider getting it just for the overall protections that it's going to offer you.
So how long did the Leaves Act or are the leaves required under each statute? For FMLA, there's an absolute right to 12 weeks. There's actually a 26-week requirement for military caregiver leave, but generally speaking, it's 12 weeks within a 12-month calendar year. The ADA leave may be a reasonable accommodation, but there's no set amount of leave that an employer is required to provide to an employee under the ADA. Courts are generally saying 6 months is reasonable. However, there is a trend away from that because the ADA is not actually a leave statute. It's designed to help employees with disabilities perform the essential functions of their job. And it's designed to, to basically offer accommodations. It's not really designed for leave. And so, requests for indefinite leave, and you're going to see this on medical paperwork that the employee's doctor is supposed to submit, and they will, recommend the accommodation, and they may recommend, 3 months of leave. But if they say leave unknown amount of time, employer is not required to provide that leave. There may be intermittent leave suggested, that would allow an employee to take off for certain doctor's appointments or physical therapy or, chemotherapy or something along those lines. But the ADA is very squishy on how long leave should be provided. Elijah?
So for workers' comp, like Christine said about ADA not being a leave statute, workers' comp also is not meant to be a leave statute. So what I want to point out before I get into the actual timelines is that workers' comp does not require any job protection. If someone is injured and you have to have someone in that position, looking at it only from a workers' comp perspective, if you hire someone else to fill that position and you don't have a job anymore for the injured employee, they're going to collect under the workers' comp scheme in Georgia. So those protections and those timelines are up to 400 weeks if it's not catastrophic. The way that's broken down is that if the employee is capable of some light duty work, then you're looking at a 350-week cap, which is about 6.5 years. If you're looking at someone who is not able to work at all, that's when you're looking at a 400-week cap. And that's getting you about 7.5 years. If it's catastrophic, if someone becomes blinded in both eyes and has an amputation from an accident, then you can extend those benefits out. But the amount of time is for the benefits, not for a protected period for leave, which is all to say you may have someone that is on light duty work for the 350 weeks. And during that time, there are several weeks or months that they are working light duty all the time. And then there may be a few weeks where they're not able to work. So just keep those two thoughts kind of separate, that they can be entitled to benefits, but they don't necessarily have to have job protection. With the one caveat that you don't ever want to terminate someone for the sole purpose of they filed a workers' comp claim. Right.
Likewise, if someone takes FMLA, don't fire them because of that. Same thing with an ADA accommodation request. I mean, I'm sure most people on this call know that, but I think we have to say that. So Elijah, you want to talk about light duty for FMLA and workers' comp?
Sure. So light duty, again, this is not something that you are required to offer under FMLA or workers' comp. Likewise, you cannot force an employee under FMLA to work light duty. And for workers' comp, you can't force them to work light duty, but you have to work within the statutory and regulatory scheme to suspend their benefits if they refuse light duty. So if a authorized treating physician in workers' comp provides, let's say the only requirement is that the person can't lift more than 50 pounds, but the job they have doesn't require them to lift more than 10 pounds. Again, purely made up. So even though it's light duty, they can perform every aspect of the job. You can, in that situation, you can let them come back voluntarily to reduce your exposure for lost wages, or you could go through a regulatory equation where you have to reach out to the authorized treating physician, have a job description approved, and then in that method, you're essentially forcing the employee to come back into a light duty job. That's a bit of a loose example, because in my example, I would actually argue that they've been released to full duty, even though they have a restriction, because their restriction allows them to do everything with their job. But just to make the point, you can offer light duty, but you don't have to. Remember, workers' comp is a no-fault system in Georgia. So if you have an employee that is capable of working light duty, but as an employer, even if you could offer that job under workers' comp as light duty, it would just be better for you to have a full duty employee in that job. In that situation, you can choose not to bring the employee back under light duty. The only requirement is that you would then have to pay them as if they were fully disabled. So that's the trade-off in workers' comp, is that you can use it to reduce your exposure, but if not, the employee is going to be essentially treated as if they weren't able to work.
Okay. So with the ADA, it's similar in that it's not required, but you'll see a lot of circumstances where someone requests to work from home as an accommodation. And, if I know we're in kind of a different world now that we're, I guess you could call it post-pandemic, where a lot of people are working from home more so now, but there are some jobs and industries where working from home is not an option, or there are only a few jobs within that business where you can work from home. And if it just so happens that there is a vacant existing position that would be remote, that employee is, would be able to do, then unless there's that circumstance, you don't have to create a remote job for the ADA. You don't have to create a part-time job under the ADA as an accommodation. Only if there's already a vacant existing position would you be required to allow that employee to step into that different role or light duty role. Okay, now we're going to get graphic and fancy with you guys, kind of bring this to life. So the first one is, what would be an ADA and an FMLA condition? Remember that the ADA, let me pull this up. So let's remember that the ADA is an impairment that affects a physical or mental impairment that affects a major life activity, and the FMLA is a serious health condition, which is essentially something that would involve incapacity or ongoing treatment. There are so many examples here, and actually we can't even think of one that would only be under the ADA that wouldn't also be under the FMLA. It may exist, but can't really think of one. So an example of the overlap would be cancer, diabetes, asthma, and COVID-19. So cancer, for example, you may have incapacity related to, the discovery of that disease. You may have ongoing chemotherapy, and with that condition, it may impact a major life activity. or substantially impact a major life activity. So you can see how the ADA and FMLA overlap here. And typically, you will, an employee will be on FMLA leave first until they exhaust their 12 weeks, and then you would shift into the ADA and look at an accommodation under that. That's how it typically works together. Oh, and then for COVID, for those instances, like, obviously, in people who are hospitalized, that would trigger the FMLA. And if it turns into a long haul recovery or long haul condition, then that's where you would work in the ADA. Like if it results in some kind of long-term lung condition or kidney failure or something like that, then you're going to end up in both there. And so what would be just an FMLA but not an ADA situation? Pregnancy would be one. Leave for a family member. And then COVID-19, I don't know if you guys recall the Families First Coronavirus Response Act, but there was an emergency FAMLA paid leave that was involved with that. That's no longer in play, but you may still see that where someone's hospitalized, but they recover fully and it doesn't end up impacting a major life activity. So it may not turn into a disability. So that's how that would work out. All right, now Elijah, I'm going to pass the ball to you.
Yeah, sure. So the next one is just that interplay between essentially a workers' comp accident, a work accident that may also implicate FMLA. Some of the, if we can go one more, we can get to some examples.
Okay.
Yeah, so here's some examples of that. A workplace fracture, a knee injury, carpal tunnel. And again, right here, we have COVID as a question mark because under Georgia's laws and the case law that is developed from that, for a virus or an occupational illness to be compensable under the Workers' Compensation Act, you basically have a multi-pronged test. And as far back as 1988, the Georgia Appellate Court kind of issued a death knell to claims for viral transmission like hepatitis or the flu by creating this peculiar risk doctrine. So without getting too much into the legal development, which I'm fascinated with, what this basically means is in almost every situation, if an employee could have been exposed to a virus outside of work, then it's not going to be a workers' compensation claim. The reason we have this here as a question mark is in Georgia, not only do we have that workers' compensation law, but we also have a separate statute that, if an employer or a facility posts this disclaimer at the front of their premises under OCGA 5116.3, I think, that they can disclaim some liability for COVID. So the State Board of Workers' Compensation has not, to my knowledge, as of yet, found it to be compensable. I think that we would have had something by now. So that one you can kind of think of is probably settled, but it could still change. There are developments happening still with the virus. For other things listed on this, carpal tunnel, for example, that could be something where you have an employee that can otherwise perform their job except for, let's say, typing for long periods of time. So they have to go out for a few days for surgery and recovery, maybe some physical therapy. That's something where it may be covered under workers' compensation and FMLA for a certain period of time together. And we will talk about this a little bit later, but another interplay here is when someone comes back from workers' comp, but then may need FMLA leave related to, let's just say, some final recovery. And you get that I think you get that tension because of the different definitions of whether you're disabled or recovered under workers' comp being state law and FMLA being more federal.
Pretty murky.
So this next area is, something that is just in the middle of all of it, and something that is a work accident, that it implicates FMLA as well as ADA, and there you have some examples like a back injury. So this is somewhere where you have, let's say, a laborer that is picking up a heavy item at work. So they fracture a disc and they have to have a discectomy or a new disc in their back and for a certain period of time. And let's just say it's a long-term employee. They may have injured their back 6 or 7 years ago and no longer be covered under workers' comp, but still have enough ongoing restrictions that they are still covered under ADA and FMLA. And I think the important thing to point out there is to remember these are separate spheres. You see in this diagram the different colorations of the different areas you need to consider stuff. But just because it leaves workers' comp doesn't mean that you don't still have to consider ADA or FMLA, and exactly vice versa. If you have someone who has exhausted their 12 weeks of leave under FMLA, it doesn't mean that they don't still have a disability that's covered under ADA, right, Christine? That's correct.
Yeah.
And the next one is, examples of all of it.
Yeah. Showing all of it. But what I was going to say is, that an ADA accommodation might be something that, has to be provided for the remainder of their entire employment. They may need, to leave for doctor's appointments once a month or twice a month for that disability for the rest of their employment. And keep in mind FMLA is 12 weeks every year, so it kind of can start back over.
And before you go to the next slide, Christine, you made me remember something that I think is extremely important to point out. Mm-hmm. When you're looking at the overlap for ADA and workers' comp, and for that matter, FMLA and workers' comp, it is very important to remember that in Georgia, under workers' comp, there's an authorized treating physician. One of those trade-offs between providing medical care is that the employer gets to limit the physicians that can provide that care. So you may, and I think this is another one of those things that could be an entire separate presentation. If y'all can't tell, I like presentations. But you may have a situation where you have a authorized treating physician, an ATP, in workers' comp that has released the employee to full duty work, but their personal physician has limited them in their ability to work because of their disability. And it may be that disability is the result of the work injury, but because it is two separate doctors, that's where you find yourself maybe being able to suspend benefits under workers' comp because they've been released as a full duty employee, but still having to provide accommodations under ADA.
Bringing it all home.
So this is just meant to kind of place a few things in the different areas just to give you an idea as to where to start. Again, it doesn't mean that something can't move from one to the next, but just thinking about it, workers' comp is these short-term, meaning less than 7.5 years, non-serious work injuries. Some of those could be a broken bone or a fracture or something of that nature. And then ADA and FMLA are more disability related rather than injury related. And so looking at how things start on this board, if nothing else, just gives you an idea as to where you want to start with your forms, or where you're starting with your discussions. So a very easy example is if you have something that's pregnancy related, I certainly hope that that is not related to their carrying out their job. So you wouldn't ever want to really look at that as a workers' comp thing, even to begin with. Mm-hmm. And just knowing where you start can really help in knowing where you want to end.
Right. Well, and I'll add to this that these are, every condition and every employee can be such a fact-specific inquiry that it's, these things are really here for you to issue spot. And if it feels complicated, or you aren't entirely sure that you're doing it right, especially for businesses that, their designated HR person might also be their CFO, or, it may not be their full-time focus, that's when you just pick up the phone and call your counsel, and help walk through it. And how do I do this process? And, another important aspect of the ADA that I haven't brought up yet, and I'll just mention it briefly, because like Elijah said, this could be a separate presentation. The ADA requires an employer to engage in the interactive process with the employee, and that interactive process is for determining what is a reasonable accommodation. And the employee is also required to engage in that process too. So it's a mutual obligation. But that process is involved. It takes time, and I see a lot of employers trip up in that area, and also I see a lot of managers kind of miss the issue spot. You may hear an employee kind of make a reference to their back hurting because their chair is uncomfortable. That's something you probably want to address with them, because I see it so frequently where an employee files a complaint saying, you didn't accommodate me, and I told you multiple times that my chair was uncomfortable and was hurting my back. Well, I have, long-term sciatica, and, that's an ADA, a disability. So it, and that's a gray area, but you just want to have this in the back of your head to issue spot it, especially if someone says that that's the reason why they're not performing to a particular level, or this meeting format is difficult for my ADHD. Could we do it where in a different format? That's sure, yes, maybe we can do that, but either way, you probably want to involve your HR in that situation there. So a couple of considerations here for the FMLA that will come up. Is it paid? No, it's not. The only paid FMLA leave that I've seen was under the Families First Coronavirus Response Act. That was emergency FMLA leave, and that has expired and is no longer in place. So FMLA is not paid. Benefits. So an employee is entitled to the continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. So, if they're supposed to be paying a certain portion and the employer pays a certain portion, then continue that as it was going while they're on leave. Bonuses and salary increases. So if an employee's been out for 12 weeks, are you required to give them a bonus or a salary increase like the other employees? Well, only if your bonuses and salary increases are unconditionally given to all employees, regardless of performance or productivity. Only then would you be required to provide that bonus or salary increase. And one thing to pay attention to, if you have various leave options within your company, not just workers' comp or FMLA or ADA, but maybe also you have some sort of sabbatical option or, just other kind of general leave. You want to make sure that if you're paying out bonuses or salaries to certain employees on this leave, you want to make sure you're giving them, the FMLA leave employees, a bonus and salary as well, because then you've got a retaliation claim. So what are your obligations when an employee comes back? Well, as we mentioned before, there are, the FMLA is a job protective leave statute. So it requires an employer to restore the employee to the same or equivalent position and benefits that the employee would have had before taking FMLA leave. And this also applies to intermittent leave under the FMLA as well. So there are situations where an employee can't be returned to the same job. Like, for example, if you have various customers and you assign certain employees to that particular customer's project, and while they're out on leave, that customer, maybe they fire you or something, or that project's completed, you can't return them to that same job. But what you have to do is return them to a nearly identical job. It must provide the same shift or general work schedule, must be in the same geographic location or proximity, must have the same or similar duties, responsibilities, skills, effort, and authority. And it must have identical pay and benefits, including overtime and bonus opportunities. And so then this question of what happens if an employee does not come back? And I think what that question is really asking is, if an employee says, or basically at the end of the 12-week period says, I still need more time, that's when you more than likely will shift it into ADA leave, assuming that the ADA would apply. And on that same question, the ADA, like I said, does not have a specific amount of leave time, but what you would do is evaluate whether you can continue to provide that leave as a reasonable accommodation without an undue hardship to you. So let's see. And likewise, under the ADA, it's not paid. Oops, I went too far. Sorry. The same. The ADA is also a job protected leave statute as well, but it's more strict than the FMLA. That one, you have to reinstate them to their original position unless there's an undue hardship. Let's see. If you can't do it, you have to assess any open position that would be available for that employee, and reinstate them with the same level of pay, the same benefits. But if you've exhausted all your options, then you're going to have to bear that heavy burden and prove that there were no reinstatement options without causing an undue hardship. But like I said, you are not required under the ADA to create a part-time position or create a remote position. But I would say and suggest, consider any amount of leave that an employee requests, get the medical documentation, get their doctor to make that recommendation, and evaluate, can we do 2 or 3 months for this person to be out? I would suggest up to 6 months. But if there's no time period for their return to work provided in that ADA paperwork, then there's no requirement for you to provide that leave. So I will hand this over now to Elijah.
So the only real difference in leave when you add the work-related aspect to it, the work injury, the work accident, is what we've talked about earlier, in that are you required to give light duty or not, and how much time? So remember, the previous numbers were 350 and 400 weeks, and there's not any, under workers' comp, there's not any job protection. So there may be periods of time where in a work-related accident there is job protection if they've elected to take FMLA leave, for example. And then there may be periods where there's not job protection. Now, there was one question that was asked that I think this is probably a good slide to discuss it, just to tie it into that job protection. But and I'm not sure if I've understood the question correctly, so I'm going to answer it 2 different ways, and hopefully one of those is what the asker is looking for. So the question is, if we need to hire someone to fill in for a spot of an employee that was out on workers' comp, what are the options for that employee when they return? Now, being a typical attorney, I'm not sure if that employee refers to the one that was hired or the one that is returning under workers' comp. But the answer for the one that was hired temporarily, I would probably say to let that person know, and I was wrong. I'm going to give you both answers anyways. I would probably let the person know that is being hired, that they are being hired to fill in temporarily until another employee returns. That is because you don't want to have them, for any reason, think that this is going to be a long-term job. Now, having said that, if they do a great job while the injured employee is out and you want to keep them on, then there's nothing that says you can't keep them on. But I would tell them up front that it is probationary or temporary or something to let them know that there is no promise of this beyond a certain point. For the employee that is returning, remember, under workers' comp, you do not have to return them to the same job. So again, let's look at the employee that you've hired as a great employee. Maybe you want to keep them in that job position. If you're not dealing with FMLA or ADA, your options for the returning employee are to put them wherever you need them, as long as they're able to do that job. Again, you're looking at what their restrictions are from a medical standpoint, mostly. So if you put them at a lower paying job, again, because of this no-fault system, the only requirement is that you pay the difference between what they were earning and what they're now earning. So let's say they're making $100 less per week in this new job, the returning employee, that goes into a calculation as to what they are owed under the workers' comp system. If you return them back to their present job, then you don't have to worry about that. If you bring them back, this returning employee, let's say you bring them back at a higher paying job, again, you're not worried about having to compensate them for that loss of income. But all of that is to say, under workers' comp, strictly under workers' comp, you can really do whatever you want with that returning employee. Again, all as long as it's not retaliatory. You don't want to say, oh, no matter who it is, if you file a workers' compensation claim, when you come back, you have to go, 2 pay scales down and earn your way back up. You don't want it to be something that is tied to them filing the claim. But I hope that answers the question. If not, we can talk about it more offline. Sorry.
And I would look at the questions, but I'm sharing my screen, so I'll just leave them with you. And
so on this slide, this is where we're taking ADA out of it and looking at just the interplay between workers' compensation and FMLA. And in this situation, you've always got this 12-week period for each year that's measured that you're going to have to deal with FMLA potentially. Under workers' comp, we've talked about the length of time under there. Now, I think one of the biggest questions that comes up is, so 2 things. 1, the drug or alcohol question, and 2, treating these as separate and not so much overlapping. So for drug and alcohol, that's a bigger discussion as to whether they are using the drugs or alcohol at work or whether they may have a drug or alcohol dependency or problem that they are dealing with and, for example, seeking recovery. But if an accident happened while they were under the influence, there are some potential defenses under workers' comp if you take a drug or alcohol test within a certain period of time. Looking at these as somewhat separate and not overlapping, there was a question as to whether an employee who has an injury at work can exhaust their workers' comp benefits and then take FMLA leave. And the 11th Circuit answered that recently for the Southeast last year in a case called Ramji versus Hospital Housekeeping Systems. And in this situation, the plaintiff had a work injury. They were released to work full duty by their workers' comp doctor, but the employer required the employee upon return to take what they called an essentials function test. So they were put in a situation to basically prove they could meet the essential functions of their job after they had exhausted their workers' comp benefits and been, or I shouldn't say exhausted, they'd been returned and released to full duty under workers' comp. So they failed the essential functions test, said that, if they had had some time to do additional therapy, they probably could have passed the test, but the employer terminated them as soon as they were not able to pass it. The employee had been essentially denied that FMLA leave to seek that additional care to return themselves to a point where they could work. So what I think Ramji stands for, this 11th Circuit case, I think it stands for this proposition that if a workers' comp injury also qualifies as a serious health condition under FMLA, then you have to provide those benefits separately, whether they are concurrent or not, or whether they're contemporaneous or not. If you have an employee with that situation, I would suggest that you go ahead and give them rights, a notice of their rights under FMLA, just to create a paper trail for yourself or for the company.
Mm-hmm.
And then the last few considerations, we're almost done. I know y'all been sticking with this, but on the next slide, we have just a few more considerations. And, as mentioned earlier, ADA doesn't expire. So if they have something that qualifies as a disability under ADA, then you have to make accommodations as required under ADA. You should assume that the FMLA serious health conditions and the ADA reasonable accommodation process travel together, but you always want to keep the paperwork separate. So there are some parts along that journey where one document may serve the purpose of both, but you need to be, or your counsel needs to be talking to you about what boxes need to be checked off for each one of those requirements under FMLA and under ADA. We talked about this earlier, but you can't require light duty of a workers' comp claimant while they're on FMLA. So even if they are capable of light duty, but they elect to take an FMLA leave, you cannot say, but I'm requiring you to work light duty under workers' comp. And then you also can't force an ADA reasonable accommodation to avoid an FMLA leave. So if you know you can make an accommodation to an employee, but they still request the leave, you have to process that leave request under FMLA. You can't just say, but I'm going to make it to where you don't have to take a leave. And then the very last substantive slide that's coming up is, what happens if you don't know about the serious health condition or the disability? So there's not any magic words, although there are some words that are a bit more magical. So if you have an employee that comes to you that says, I'm requesting FMLA leave for a serious health condition, you should absolutely treat that as a request for FMLA leave to treat a serious health condition. But in the situation like we talked about earlier, where you have someone that says over and over and over again that the chair is causing their back to hurt, that may create a situation in which you should probably inquire just a little bit further. So you don't want to assume that there's a disability. That's where I think a lot of employers create a situation is, you have someone that comes in and you think you smell alcohol on them, or you think that you detect some inability to perform their job on a motor function level. You wouldn't want to say to them, are you drunk, or did you take too much medicine this morning, or something of that effect, because then you're opening yourself up to whatever the answer is. But if you ignore a situation in which you should have known, so you have an employee that is late to work, and you've asked to have a conversation with them about their attendance, and as they sit down, they say, I can't believe I was so late today. I was sick from the chemotherapy. Well, you can't just ignore that and say, I'm glad you brought up your attendance. That's what I wanted to talk to you about, and only go from there.
Here's your write-up.
Yes, exactly.
Yeah.
So it's a bit of a balancing act, and there may be some situations. I mean, I have certainly had clients before call and say, I'm going to be talking to this person about this. Here's the facts. What should I do if this happens? Or, maybe you're expecting that someone is going to proactively request an accommodation or a leave to avoid impending disciplinary action. That's another situation that happens. So keep this in mind, but don't necessarily let it control every thought that you have about a conversation you have with an employee. Sometimes a headache is just a headache.
Right. Well, and kind of getting to our takeaways here, this is mostly about issue spotting. Especially for managers, the technical compliance here with these leave laws is not your job. But there are some really important reasons why you should flag that and take it to HR and get the appropriate paperwork on it. Because, for example, if that employee, who asked for the modification to the meeting format because of ADHD, if you say, sure, we'll rearrange that, and you rearrange it, but it's never put in writing anywhere, then down the road you have, the EEOC complaint saying, well, I asked my manager, I told him or her about it 6 months ago, or 3 months ago, and they didn't do anything about it. And then there's not paperwork there to clear cut show that, yes, we modified this meeting specifically as a reasonable accommodation for your disability. Then it's he said, she said, and you have an expensive settlement on your hands because, let's be real, not many businesses have the $150K to hash it out in federal court. So you're going to, end up with a $40, $50, maybe even $60,000 settlement on that. So it's really about issue spotting and getting the paperwork. We're not here to make your job more difficult. We're here to help and, pass the ball to us on this stuff. If you need ADA paperwork or ADA forms, FMLA forms, workers' comp forms, we can help you get that especially if you want it specific to your company rather than like a form one that you find online. So we can help with that. But one of the favorite lines around here is being unreasonably reasonable, especially when it comes to FMLA, ADA, and I think workers' comp is a little more standardized, but ADA can be so squishy that being unreasonably reasonable now will save you the fire that you have to put out later. That's an expensive demand letter or EEOC charge, or worse once you get into federal court. So we're just trying to save you money and headaches yourself with this kind of stuff. And if all this kind of blurs over, there are questions you have, we're here. Here are our email addresses, and email us, we'll call you, or call us at the main line on the internet, whatever. So I don't know if we have time to go through questions. It's almost 12:30, but I guess if anyone wants to stick around, we can. Mary Kay, you want to chime in?
Yeah, that's fine.
Okay, all right. Let me see if I can see them here.
I think the only one question was in the chat box that Elijah addressed, but I do see that there's another he would like to discuss further and give exact examples of their organization.
Yeah, we've touched base, and what my response was that I'll tell to everyone is feel free to write down Christine and my contacts information. If you want to give us a call at the firm and talk to the administrator to try and find a time, that number is 404, I'll repeat it, 881-1288. Again, that's 404-881-1288, or at least I hope that's the number. That's what I give everybody. So give us a call or send us an email, and we can try and find a time to discuss if it's a particular question that has to do with specific facts. But if it's I think that number was correct. Yeah.
You're right.
Okay. But if you have any general questions, certainly happy to stick around for a bit and discuss.
Well, this is just terrific information. It is very complicated and confusing. So I think that hopefully you clarify questions people might have. I just want to thank Elijah and Christine, both of you, and Stanton Law has just been a terrific partner for the Georgia Urban Ag Council for the last several years since I've gotten to know Todd. You guys do great work, and I know you're doing a lot of work for many of our members. So I highly encourage anyone on the call that if you have legal questions or need legal help, contact the good folks at Stanton Law.
Awesome. Well, thank you so much for this opportunity. I'm thrilled to be here and look forward to connecting with some of you guys later.